Hi, everyone. All right, welcome to Chapter 7, Parties to Crime. This is Week Six's lecture. And real quick before we get into it, I just want to say that this is the last lecture that, really is just going through the textbook page by page. The next week's lecture is about literally the last chapters, and it's just talking about the different types of criminal crimes, and criminal crimes is redundant, of criminal offenses, and getting into the nitty gritty of those pieces. So this is the last one that's kind of like setting up the established information. So there'll still be stuff from the book next week that'll be as part of the lecture, but it won't be just me going through the book, explaining things, talking about them, hitting the key points, things like that. It's going to be a little bit different next week, just simply because, we hit that point. So anyway, this week we're talking about the parties to crime, and if you did see, I posted the case study report before this video came out. Again, apologies in my intro video for the week, which again is late. You will see and hear that I was sick over the weekend, but I wanted to make sure that at least the assignment was available. So this is going up as soon as possible. Anyway, parties to crime, not the woo parties, but a party as in individuals who are involved. And so that is really what the focus is in this lecture. So I will tell you right now, this lecture is going to be fairly short. It's going to be like one of those early week lectures. There's not a whole lot of content to go into. There's stuff to talk about, but it's by this point, with everything else we've talked about, it should be more of just like fleshing out a little bit or understanding a little bit better. Okay. Sorry about that. If you could hear that, that was my ice in my cup. So, as I said, when we're talking about parties to crime, we're talking about individuals, and that's kind of the big important piece here, is that this entire thing is looking at who is involved and what are their roles. And so when we talk about it, we're talking about the people who are directly involved, not just victims. And so one of the things we are going to talk about next week with types of crimes is inchoate crimes. Those just mean they're incomplete. They were not fully finished. It's like attempted murder, things of that nature. Again, we'll talk about it next week. But those crimes tend to have multiple pieces involved as well. So, but that's neither here nor there. Defendants working together with a common criminal purpose or design are acting with complicity. They are complicit. You might have heard this term, not necessarily in criminal justice, but you probably heard the term complicit. It means that you are okay with it. You are going with the flow with it. So if individuals are working together with the intent to commit a crime, they are complicit, and that would mean that they are both equal parties to a crime. However, when it's varied, and so let's take this back a second. So often, and this is true, more than one criminal defendant plays a role in the commission of a crime. I skipped that because I didn't highlight it, but I should have started with that piece anyway. Most crimes are not just one-to-one. There tends to be some kind of other layer to it. People who work together, they're accomplices, they are complicit with each other, they work together. Whereas people, sometimes it's not necessarily at the same time. It gets a little fuzzy, and so when participation in criminal conduct varies among defendants, and notice I highlighted this in red, an issue arises as to who is responsible for which crime and to what degree. And this is the important piece, and this is why we're talking about parties to crime. The different levels of involvement lead to different issues, and the issues, these are the three questions that come up when we talk about this, is who is responsible for which crime and to what degree. The moment you have more than one individual, more than one defendant who is involved in a case, you need to figure out who is connected to which crime and at what level. And sometimes there's overlap, and that's important to note. And that's why this is important to just kind of identify that the issue with multiple people is who does what in what way. And if you're familiar with like true crime series and things like that, I'm sure at some point you've seen or heard, well, this person was the plan guy, this one was getaway, and things like that. Like, those are oversimplifications, but yes, those are exactly the types of things that this is talking about. And so, obviously, like I kind of hinted at, Chapter 8, inchoate offenses, which will be next week, they look at crimes that necessarily involve more than one person, such as conspiracy and solicitation, as well as other inchoate or incomplete crime attempt. So these are the big ones that you're going to hear about next week with the inchoate part, is conspiracy, solicitation, and attempt. Obviously, it'll make sense next week, but I just wanted to highlight in gray that this is something we'll talk more about next week. We'll kind of tie it back in with this. So, again, when we talk about people working together, we have to remember that, there's different levels. And so in early common law, parties of crime were divided into 4 categories, and that's what we have right here. Our four categories of participation when we're talking about accomplice liability. And so, very simple. We started in early common law with 4, and now we focus really on 2. And I'm sure you've heard the terms for the 2 now. But you might have even heard the original 4. So the early common law 4 is, number 1, a principal in the first degree. This is the person who is the direct committer of the crime. This is the individual, this is the actor that has committed whatever crime it is. The principal in the first degree, you're top. Principal in the second degree is someone who is present at the scene of the crime and helped with the commission. So this is an individual who did not, say, robbing a bank. You're not the person that put the gun up to the teller's face and said, put the money in the bag. You're just the person who stood around and said, nobody move. You are principal in the second degree, not principal in the first degree. In that kind of situation, of course, that's a very fantasized and way more complicated. But hopefully that makes sense. And then we get into the next level. The third level for common law was accessory before the fact, which you weren't present at the scene of the crime, but you helped prepared for it to happen. So the plan person. And then there's accessory after the fact, the fourth category. And this is, you didn't necessarily help before, but you helped in some way after its commission, whether that's providing, safety, comfort, assistance, escaping, avoiding, bandaging up someone who was shot during this. Like, you're helping after the fact to avoid this stuff. That would be an accomplice or an accessory after the fact. And so this is part of that accomplice liability. So like I said, that's the original, the early common law 4 category breakdown. Nowadays, most states, the federal government does this. Our state does this. I actually didn't even think to look at what states still have principal in the first, principal in the second, accessory before, and accessory after. But most of them, like I said, is principal and accessories now. Those are the 2 more common ones, and they do, they follow with common law. They just combine them together. Should be pretty straightforward. Principal is the individual who committed the crime, and accessories are, people who assisted. Although all accomplices, and notice I did highlight this, all accomplices have equal criminal responsibility. So while the criminal actor is referred to as the principal, in this style, any accomplices have equal criminal responsibility. So you are a party to crime. You were an accomplice. You helped with the committing of the crime. You are equally criminally responsible. And that's the important piece to note there. This is why issues of harboring a fugitive is an offense. It's breaking the law because you are helping them avoid arrest. That makes you an accomplice, and you have equal criminal responsibility. So obviously there's a lot more with it, but this is the important starting point for it. And so accomplices under most states and federal statutes, they're responsible for the same crime as the criminal actor or principal. However, and notice I underlined this too, accomplice liability is derivative. And all this really means is that the accomplice does not actually have to commit the crime to be responsible for it. So the idea is that an individual who willingly participates in furthering criminal conduct should be accountable for it to the same extent as the person who actually committed it. So that's what they mean by its derivative. You might have heard that when people talk and review about books and movies and shows like that, it's derivative. It means it's almost the exact same as something else. This is what we're talking about here, is that accomplice liability is derivative. You are saying, yes, this is okay, you're willing to support this, so you should be charged to the same. So the degree of participation, this is the part, and again, often difficult to quantify, and that's important. Like, how do you determine the degree of participation? Did you open your house to someone who was evading the cops, and did you know it? Or did you open your house to a stranger who you thought just needed a place to sleep? Like, what does this actually come down to? And so statutes and cases, so then case law, has attempted to segregate blameworthy accomplices based on, once again, criminal act and criminal intent elements. So those actus reus and actus and res mens, these two come back. The criminal act and the criminal intent does play a part when we try to consider what level, what degree of participation that an accomplice does act in. And so we're going to look at the accomplice act first. And so in the majority of states, again, and we are in that majority, surprisingly, the idea is that the accomplice must voluntarily act in some manner to assist in the commission of the offense. So this is not coerced, it's voluntarily. Some common descriptors of the criminal act element required for accomplice liability are aid, abet, assist, counsel, command, induce, or procure. Examples of actions that qualify as the accomplice criminal act are helping plan the crime, driving a getaway vehicle after the crime's commission, and luring a victim to the scene of the crime. So notice, the criminal act for an accomplice, that they are assisting. They are aiding, abetting, assisting, counseling, commanding, inducing, or procuring. These types of actions that qualify as this are planning a crime, driving a getaway vehicle, or luring a victim to a scene of the crime. So, in the model penal code, aids or attempts to aid such other person in planning or committing the offense. If you've helped in any way, shape, or form, and it falls under any of these possible areas, you are equally responsible for said crime according to our laws. In many states, and this is where things get wonderfully awkward, and I'm not sure, I tried looking for PA and I couldn't tell if words were enough, but in many states, words are enough to constitute the criminal act element required for accomplice liability. Again, I don't know if we are one of those. But mere presence at the scene of the crime, and even presence at the scene combined with flight, as in you ran away from the scene, is not sufficient to convert a bystander into an accomplice. And so really what this is getting down to is just because an individual was at the scene of the crime and ran away, it's not necessarily saying that the bystander is an accomplice. but if you said words, it might be depending on the jurisdiction. However, and please note, I have this highlighted in a different one because let's recall that in the previous chapters, we've talked about that sometimes there is a legal duty to act, like Good Samaritan laws and things of that nature. If that is in place, if someone is present at the scene of the crime without preventing its occurrence, as we kind of talked about there, you could be liable as an accomplice because you have a legal duty to act. This is where things get so interesting and so complex. And so obviously legal duty to act also would include those special exceptions with, employer, employee, military service, parental, hint, hint, nudge, nudge. I'm trying to help you with one of our case study pieces. Anyway, model penal code also says in relation to this that a person is an accomplice of another person in the commission of an offense if, having a legal duty to prevent the commission of the offense, fails to make proper effort so to do. And all that means is just if there's a legal duty to act, you are considered an accomplice if you don't help prevent the crime. Yes. Okay. And so I wanted to highlight this because it keeps going back, and I do like that we, are reusing examples from previous chapters, and we're kind of like building on them. So I noticed I did the grade out because I don't really, not going to go too deep into it, but if you remember, one of the examples from chapter 1 was women shopping and they shoplifted. So in that situation, we're just going back to that example. So the highlighted piece, none of the details have changed. That's just the quick, brief summary. So in the case, I just want to highlight on the underlined pieces that I have underlined here. This is to help point out why it's lacking the accomplice act component. So in the case, Clara has probably not committed criminal act element required. Although she was present at the scene and did not alert security guard, mere presence at the scene is not enough. She fled the scene when the alarm went off, but presence at the scene of the crime combined with flight is still not enough. It's important to understand that depending on where it is, typically this is not enough. Even though she saw, she knew, she didn't stop it, but the fact that she was not directly involved with it at all does not mean that she was an accomplice. However, we can make it if we are in different jurisdictions. If we were in a place with, say, a Good Samaritan law, she definitely would be an accomplice because she, helped her friend essentially get away with this. So here we have a different example, and I just want to emphasize that every once in a while the book gives us an example that's just so not what I expect, and it's realistic, but it's over the top. But this is an example of accomplice act. And just a quick warning in the book as well as here, this is a mention of child abuse, so just letting you know. So Phoebe, the parent of a 2-year-old named Eliza, watches silently as her live-in boyfriend Ricky beats Eliza. In Phoebe's state, parents have a duty to come to the aid of their children if their safety is threatened. Ricky severely injures Eliza, and both Phoebe and Ricky are arrested and charged with battery and child endangerment. Phoebe probably has committed the criminal act element required for accomplice liability in many jurisdictions. She does not physically act or personally act to physically harm the child, but her presence at the scene and her legal duty to act when she did not, that makes her an accomplice. That makes her equally responsible and liable for said instance. So she is charged with with committing battery and child endangerment as an accomplice, and both she and Ricky are subject to criminal prosecution. Plain and simple, pretty straightforward. This is the second time I'm saying hint, hint, nudge, nudge. These kinds of examples are related to one of your case study responses. So if you actually watch the lecture videos and pay attention, I'm giving you huge hints on what may or may not be answers and what the issues are. I'm not going to outright say it. You have to read between the lines. But as always, I have notes on some of my things like PA. Typically, I write a note of like PA specifically for me to remind myself that these are like verbatim what we do, especially when it's something weird. But so criminal intent element required. So this is where we get into the intent part. For accomplice liability varies, and it depends on the jurisdiction. In many jurisdictions, and this is a yes, PA, this is it, accomplice must act with specific intent or purposely when aiding or assisting the principal, and that is important. So that does vary a little bit, but here in the state of Pennsylvania, an accomplice is someone who acts with specific intent or purposely. It's not just happenstance or reckless. It's specific intent and purposely. And so the Model Penal Code, this is actually pretty close to what the wording we use in our official Pennsylvania statutes, but with the purpose of promoting or facilitating the commission of the offense. Model Penal Code, we use pretty much the same wording, but that is scary close to what we have. And actually, I'm just going to bring up real quick, there is a web page that I have, and I'll make it available on Blackboard. It is for the state of Pennsylvania. It is it's Title 18, Crimes and Offenses, and it is the legalese of our entire state of Pennsylvania, each law subsection and all the specific details, and this is how I've found so much of this wonderful information about whether PA does this or not. So I just wanted to let you know that, yes, if you are interested and you want to look through it, it is mind-numbingly boring and black and white and all in the very legal terminology, much like the Model Penal Code is. So if you like it, you're going to love that page. If you hate that stuff, you're going to take 5-second look at it and be like, I can't do this. So just wanted to let you know. So obviously then in other jurisdictions, like I said, us in PA, we're very specific intent or purposely. In some other jurisdictions, if the crime is serious and the accomplice acts with general intent or knowingly or has awareness, the principal will commit the crime with his or her assistance. Intent to further the crime's commission could be inferred. So we don't really have that infer part. The general intent or knowingly, it's a fine line, and I say that because when I say we, PA looks for specific intent or purposely. However, there are some of our pieces that go general intent and knowingly, but it varies. It kind of bounces around. In a minority of jurisdictions, only general intent or acting knowingly that a crime will be promoted or facilitated is required, regardless of the crime's seriousness. So this is not us. This is definitely something that we also kind of do, but a lot of it says specific intent. So that's where it gets kind of fuzzy. But so an example of accomplice intent. Notice I color-coded it so that this one example we can look at how the different levels with a specific intent or purpose, general intent or knowingly, or general intent knowingly without seriousness of the crime, we can identify each piece. So Julian, a hotel owner, rents a hotel room to Winifred, a prostitute. Plain and simple. In a state that requires an accomplice to act with specific intent or purposely, Julian must desire Winifred to commit prostitution in the rented room to be Winifred's accomplice. Evidence that Julian stands to benefit from Winifred's prostitution, such as evidence that he will receive a portion of the prostitution's proceeds, could help prove this intent. Under this kind of idea, it is very hard to prove that Julian is actually an accomplice to Winifred. In our serious crimes, you act with general intent or knowingly. If Julian's state allows for an inference of specific intent or purposely with serious crimes, when accomplice acts, it is unlikely prostitution is a felony, so that would give rise to the inference. So really, again here, it is unlikely if it's not a felony, it's probably a misdemeanor, which it is in most places, or decriminalized in tiny little areas. There wouldn't need any kind of inference here. But if Julian's state requires only general intent or knowingly for accomplice liability, regardless of the crime's seriousness, to be deemed an accomplice, Julian must simply be aware that renting Winifred the room will promote or facilitate the act of prostitution. So if he knows that Winifred is a prostitute, he knows that in a minority of jurisdictions where only this is required, he would be an accomplice. In the other two, unless prostitution is a felony, this doesn't matter. And here, unless he actually knows for a fact that she is, and that he's going to get some money because, not just for renting the room, but because he's encouraging prostitution, he's not an accomplice. So that's why I really like this specific example, and I wanted to identify those three different components so that you could see how the level of intent kind of varies. So natural and probable consequences doctrine is the idea, just very basically, that if you know that it could lead to it, you probably should be under this. So accomplice liability should be imputed only to blameworthy, deserving defendants. This is an important notion. This is what we believe as individuals who believe in a criminal justice system that works. And if you're in this class and you plan to go into criminal justice, I imagine that you believe that, our system should work right or works in some way, shape, or form. This is the idea as well, that liability should only be imputed upon blameworthy people, not just anyone. However, in some jurisdictions, if the crime the defendant initially furthers is related to the crime that is actually committed, the defendant is deemed an accomplice. So in that kind of way, and legal causation back in Chapter 4, foreseeability is the standard, and we kind of talked about that a little bit. So specifically, under the natural and probable consequences doctrine, if the defendant assists the principal with the intent to further a specific crime's commission, and the principal commits a different crime that is foreseeable at the time of the defendant's assistance, the defendant could be liable as an accomplice. So really all this is saying is that if someone was an accomplice and said, oh, you want to go steal this? Yeah, by all means, go ahead and steal it. And you're trying to encourage them, but when they go to steal it, they also, do some other things. Maybe set the place on fire. The person was a firebug, someone that was an arsonist, and you're like, it was believable, natural, and probable that they were also going to light it on fire. You would also be considered liable for the arson as well as the theft. So several jurisdictions have rejected this doctrine as overly harsh extension of accomplice liability, simply because, maybe you encouraged one crime but not the other. It gets very hazy. And so, again, this is a sensitive subject and a hard topic example, but it really kind of highlights the issue and why the natural and probable consequence doctrine is so complicated, and why some jurisdictions say, yeah, it's too heavy, but some people would go, no, it makes sense. So in the example, Jose, our principal actor in all of this, he shows up drunk and unruly to his friend Abel's house and tells him he wants to beat the hell out of his girlfriend, Maria. Jose asks Abel to drive him to Maria's house, and Abel agrees. So already we have Jose is our principal, and Abel is our accomplice. Abel drives Jose to Maria's house and waits in the car with the engine running. Jose forces his way into Maria's house and then beats and thereafter sexually assaults her. If Jose and Abel are in a jurisdiction that recognizes natural and probable consequences, the trier of fact could find that Abel is an accomplice to the battery, burglary, and sexual assault of Maria. Abel appears to have the criminal intent required to be an accomplice to battery, because he assisted Jose in his quest to beat Maria. He said, all right, I'll take you. burglary and a sexual assault were foreseeable when Abel drove a drunken, angry Jose to Maria's house, clearly the natural and probable consequences doctrine would extend Abel's accomplice liability to those crimes as well. If Abel is not in a natural and probable consequences jurisdiction, the trier of fact must separately determine that Abel had the criminal intent required to be an accomplice to all three. Abel's intent will be ascertained according to the jurisdiction's accomplice intent requirement, either specific intent or purposely or general intent or knowingly. And this is why I said this is a complicated issue. This is a good example of why this matters. Should Abel be legally responsible for all three charges? Should he be charged for all the same things as an accomplice as Jose? This is one of those, this is not he said, she said, this is facts. He said this, he did this. What is the right answer here? Is it too broad to say that he encouraged all three of them? Or is it fair? And I'll leave that as a ethical and moral question up to you. But I just wanted to point it out that this is a really good example, despite how unfortunate it is. But yeah, we'll go with that. So, consequences of accomplice liability. So obviously, we talked about what it means to be liable, but what the heck are the actual consequences? So, as we've already kind of said, they are responsible for the crimes that the principal commits. This means that you are essentially being charged at the same level. So in theory, the accomplice is liable to the same degree as the principal. So in previous examples, Phoebe is criminally responsible for battery and child endangerment, Julian is criminally responsible for prostitution, and Abel is criminally responsible for battery and possibly burglary and sexual assault. That's the concept around accomplice liability. The principal should also be criminally responsible for his or her own actions. And this is where we get the, but hold on, things aren't always black and white. Yes, the principal offender should be criminally responsible for their own actions. However, occasionally a situation arises where the principal is not prosecuted or acquitted because of a procedural technicality, evidentiary problems, or a plea bargain. In theory, excuse me, I needed more liquid for my dry throat. This means that in theory, an individual who committed a crime could get away with the crime, be acquitted due to some kind of logistical issue, a procedural technicality, and an accomplice could be criminally charged for it despite not being the principal offender. So if you're thinking to yourself, how is that fair? Well, that's kind of the issue here. So prosecution of an accomplice when the principal is not prosecuted or is acquitted. In this kind of situation, in many jurisdictions, the trier of fact can determine that a defendant is an accomplice even if the criminal actor or principal is not prosecuted or has been tried and acquitted for the offense. But they can be liable for a crime that they didn't commit, even when someone who did commit it is found not guilty. If a defendant helps another commit a crime with the intent to further the crime's commission, punishment for the completed crime is appropriate. And that's where I say it is fair. It's not fair, but it's fair. I have issues with people getting off and getting away with a crime. But if an individual, the idea with this is that if you helped with the intent to further the crime, you wanted it to happen, you should be punished appropriately. So just because one person got away with it doesn't mean you get away with it. Model Penal Code puts it as an accomplice may be convicted on proof of commission of the offense and of his complicity therein, though the person claimed to have committed the offense has not been prosecuted or convicted, or has been convicted of a different offense or degree of offense, or has been acquitted. So, just to kind of get us in, going back to the example of Jose and Abel, thinking about this, so just to go real quickly without going back into it, so assume that after Jose burglarizes, beats, and sexually assaults Maria, local police arrest the two men. The police take them to the police station, put them in separate rooms for interrogation. Police officer who interrogates Jose is a rookie and forgets to read Jose his Miranda rights. Thereafter, police contact Maria, but she refuses to cooperate because she fears reprisal. The DA decides not to prosecute because, well, the tainted interrogation. In the case, Abel could still be prosecuted for battery and all the other things as an accomplice. Although Jose is the principal and actually committed the crimes, it's not necessary for Jose to suffer the same criminal prosecution punishment as Abel. If the elements required for accomplice liability are present, Abel can be fully responsible for the crimes committed by Jose, whether or not Jose is prosecuted for or convicted of these offenses. In plain, simple words, if the elements required for accomplice liability are present in any case, whether the principal offender is found guilty or not, the accomplice can be prosecuted and convicted for those offenses. So hopefully that makes sense. So this is there are some really good examples here. I actually do remember the Nancy Garrido sentencing, and I remember this case when it first happened. It was dark, but so both these are real world sentencing videos about accomplice, and if you're interested, I do recommend looking into these. Both of these are good examples that the book puts forward. I don't want to go into either case too much. Just know that Philip and Nancy Garrido, Philip kidnapped a young girl and held her captive, and obviously Nancy is an accomplice. But the question comes, she's a wife. Does that count as that? Hint, hint, that's related to one of our things as well. And then I cannot pronounce the name right. I want to say Galani, but the individual was an alleged terrorist who was in Guantanamo Bay for the longest time, but was eventually released from Guantanamo Bay, not in the sense of released, but when President Obama went into office, he put for the shutdown of Guantanamo Bay, and this individual was put on trial, and he is serving a life sentence in a private prison. I believe the most recent thing I read was, I think it's in Michigan where he's at now, but it's another one of those accomplice liability cases. So they're both really good examples. Even if you don't watch the YouTube video, if you just want to look up the cases themselves, it's very interesting. It's worth looking into, but I'm not going to spend any time on them because I think that's a cool, fun for you thing to kind of do. Is if you're interested in more, look it up. And I don't mean that in like a rude way. I just mean if you're interested and want to know more, there are tools available. There's plenty of examples out there. All right. So second part of this chapter is second part of 3 is vicarious liability. So you probably heard the term vicarious before. Probably, parents live vicariously through their children or things like that. Obviously, vicarious means that it's through someone else. So the concept itself is transferring liability from one defendant to another. When we talk about vicarious liability, however, and this is important, notice that I have this highlighted in red. I wanted to identify this and I have it highlighted. Vicarious liability should not be confused with accomplice liability. Accomplice liability is based on the defendant's participation in a criminal enterprise and complicity with the criminal actor or principal. This is how it's different. Vicarious liability is not the same as accomplice. Accomplice liability is based on defendant's participation in a criminal enterprise and complicity with it. Vicarious liability transfers the defendant's criminal responsibility for the crime to a different defendant because of a special relationship. And this is where we get into that, employer, employee, parent kind of area. So, criminal law is common between, in Chapter 1, one of the things when this first came up, vicarious liability in criminal law is common in employer-employee situations. It's also the basis of corporate liability, which we're going to talk about. It's like a subsection of vicarious liability. Its roots are in vicarious liability, but as we've advanced as our society and corporations have become more and more vast and less focused, it's become an issue where we have to have this. So just to get right into corporate liability so we can get back to general vicarious liability. Corporate liability in early common law, corporations were not what they are today at all. If you looked at a quote-unquote corporation in the 1800s, 1700s, like they were either owned by the government or they were owned by rich landowners. It wasn't, individual CEO starts a business and there are board of trustees and all this. No, it was either owned by the government or owned by land. In modern times, American corporations are private enterprises, so they're not government, they're private, whose actions can seriously injure other individuals and the economy. So because of that, a corporation can be criminally responsible for conduct apart from its owners, agents, or employees. So again, in general, this is vicarious liability. This is just a particular subset focused on corporate. So if for whatever reason in this class you go, you know what, I want to go to law school, but I want to be a corporate lawyer, great, you're going to know a lot about this. But so the idea here is that corporations can be criminally responsible for conduct. So vicarious liability that transfers criminal responsibility for an offense from an agent or an employee of the corporation to the corporation itself based on the employment relationship. Of course, agent or employee also is responsible for the crimes they commit. This means just because you work at a corporation and you make a criminal act, the corporation is the one that takes the fall. No, you get in trouble too. So a corporation is vicariously liable only if an agent or employee commits a crime during the agent or employee's scope of employment. Highlighted in blue, model penal codes phrasing, a corporation may be convicted of the commission of an offense if the conduct is performed by an agent of the corporation acting in behalf of the corporation within the scope of his office or employment. This is where it makes more sense than just you committed a crime while on the job, because that's not how it works. Criminal punishment for a corporation is generally a payment of a fine, but it's important to note a corporation is vicariously liable. They have corporate liability if the agent or employee commits a crime during their scope of employment. But what the Model Penal Code emphasizes is that acting in behalf of the corporation. That's the piece. So, the example our book gives, I really enjoy. Harry, an employee of Burger King Corporation, shreds corporate documents in his office when Burger King is sued civilly for sexual harassment in a multi-million-dollar class action suit. Right there. Harry, an employee for Burger King. We have our corporation and our individual. He shreds corporate documents in his office when they find out that Burger King's being sued. Whoa. Using modern theories of corporate liability, both Harry and Burger King could be criminally prosecuted for obstruction of justice. It's vicarious because it's not that, Burger King directly said, hey, shred everything. Harry took it upon himself, acting on behalf of the company, to shred the documents. So its relationship with Harry as an employer and the fact that Harry is acting within the scope of his employment. Vicarious liability is distinguished from accomplice liability, where the accomplice must be complicit with the criminal actor. The owners of Burger King, who are corporate shareholders, did not actively participate in Harry's conduct, although they will share in the punishment if the corporation is fined. So this is why I said it's important to note. It's not just you commit a crime while working somewhere. No, just because you decided to commit stolen identity theft while you worked at Walmart, that's not how that works. Walmart doesn't get in trouble for that. I mean, they'll get in trouble for allowing that, but it's not the same way. It's not fully vicarious. It's corporate. It's a weird one. All right. So now we can talk about individual criminal vicarious liability. So generally speaking, criminal law disfavors criminal vicarious liability, exception being corporate liability. Reason we say this is because criminal vicarious liability, it violates the entire basic precept that individuals should be criminally accountable for their own conduct, not the conduct of others. It's one thing to be an accomplice. It's another thing to be vicariously liable. So, although accomplice liability appears to hold an accomplice responsible for principal's conduct, in reality, the accomplice is committing a criminal act supported by criminal intent and is punished accordingly. What this comes down to is essentially, in most places, when they look at this, an individual, they don't view them as vicarious liability, they view them as accomplice because they are supporting criminal intent and they have at least some of those required elements, and so they're being charged accordingly. However, some examples of statutes holding parents criminally responsible when their children commit crimes that involve weapons belonging to the parents and offenses criminalizing contributing to the delinquency of a minor. These are they're different, but they're the same. So there are statutes that appear to impose criminal liability vicariously, but what they are doing is they're actually holding people responsible for their own criminal conduct. And so what this means is that in a situation where a child commits a crime involving a weapon that belongs to the parent, the criminal conduct is that the parent didn't properly store, secure the weapon. Of criminalizing contributing to the delinquency of a minor, it's directly related to your own, as a parent, criminal misconduct and improper ways of involving your child. So in both of the examples right there, parents are held accountable for their conduct that allowed it to happen. So the law, and what I really wanted to emphasize here, because this is important, it's related to both of our case study reports for this week. The law is evolving in this area because the incidence of juveniles committing crimes is becoming increasingly prevalent. It's not just in juvenile justice that we need to worry. It's in general. This is stuff that is changing. Law, and I said it way back when, law is not black and white. Criminal justice is not black and white as much as it wants to be. It's gray. It's always changing. It's always adapting, even though people don't want it to sometimes. We need to be aware that things are changing, and what's in this textbook now and what I'm talking about now, 20 years down the road might be very different. It depends. Heck, everyone in this class was either born after, or I'm pretty sure actually everyone in here was born after or has spent a majority of their life after the Roe v. Wade case. Actually, I'm confident to say everyone was born after. Roe v. Wade. And we're living in a time where that was overturned. Law is evolving. Sometimes not in the right way, but law is evolving. We need to be aware that things are changing. But what I want to end with here, talking about criminal vicarious liability, again, other than corporate liability, we don't tend to see this because technically a lot of the ones that are out there that we could consider vicarious liability, because I even mentioned parents, those special relationships, they tend to be more of holding the parent accountable and treating it more as an accomplice rather than vicarious liability. All right. And so now we get to talk about accessory. So going back to early common law, we had the four distinctions. We had two principles and two accessory before the fact and accessory after the fact. In modern times, accessory before the fact is an accomplice. And an accessory after the fact is an accessory, which is a separate and distinct offense. However, some states still call the crimes of accessory after the fact, or hindering prosecution. It doesn't matter what the phrasing is. But it's important to note that accessory before the fact is considered an accomplice, and accessory after the fact is just an accessory in most modern definitions and understandings of those words. The difference between those two is crucial. And again, an accomplice is responsible for the offense the principal commits. An accessory is guilty of a separate crime that is almost always a misdemeanor. And so if you remember way back in the beginning of this lecture, I said, you helped in aiding and abetting and letting someone get away, you can be charged, yes. Maybe not as an accomplice, but as an accessory. And it'll be a misdemeanor, but it will be hefty. So accessory act. The criminal act element required for an accessory in the majority of jurisdictions, this is true for Pennsylvania, is aiding or assisting a principal in escape, concealment, or evasion of arrest and prosecution or conviction after the principal commits a felony. Please note, felony, not a misdemeanor. In most states, a defendant cannot be an accessory to a misdemeanor, although in some states, a defendant can be an accessory to a high-level or gross misdemeanor, and we are one of those that is high-level or gross misdemeanor. I believe we can also hold someone as an accessory if that has been committed. In a minority of states, not us, but the defendant can be an accessory to any crime. Yeah, we're not that. That's the good news. But again, in many states, much like with accomplice, words are enough to constitute the accessory criminal act element. So often special categories of individuals are exempted from liability as an accessory, typically family members by blood or marriage. Because, let's be honest. They tend to be like, you don't just turn your back on family. That kind of concept is there in our own example, or in our own worldview. Anyway, so a good example of this actually in practice is here. Jim wakes up late at night to the sound of someone pounding on his door. He gets out of bed, walks down the stairs, opens the door. His father, James, is on the doorstep. James's eyes are bloodshot, and he is swaying slightly on his feet. He tells Jim that he got in a car accident and needs to come inside before the police find out. Jim steps aside, lets his father enter the house. Smell of alcohol on his breath is apparent, and thereafter allows his father to spend the night without contacting the police about the accident. Jim has probably committed the criminal act element required for an accessory in many jurisdictions, because he allowed his father to escape arrest and evade an alcohol screening after leaving the scene of a car accident, which is most likely felony drunk driving and hit and run. He also sheltered his father for the night, concealing him from law enforcement. If Jim is in a state that exempts family members from accessory liability, he may not be subject to prosecution because the principal of crime is his father. If he's not in a state that relieves family members from accessory liability, he could be fully prosecuted for and convicted of this offense. So this is what I mean. If you're in a place that allows this kind of exempt status, then yeah, he's okay. But in general, it hits. All right. Let's talk about accessory intent. So we talked about the act itself. Let's talk about the intent. The criminal intent element required for an accessory has two parts. First, the defendant must act with general intent or knowingly or awareness that the principal committed a crime. So the first thing that they need to do is they must act with general intent or knowledge or an idea that some crime has been committed. The second piece that's required is that the defendant must help or assist the principal escape or evade arrest or prosecution for or conviction of the offense with specific intent or purposely. Notice we have a combination. We have general intent or knowingly, and we have specific intent and purposely. That's big. The intent requirement is both pieces. They have to have a general understanding they committed a crime, and they must act with the specific intent or purpose to avoid that. They're trying to help. So with our previous example, Jim is aware that James committed a crime because James told Jim he got into an accident and his intoxication was apparent. But Jim purposely helped James evade arrest and an alcohol screening. Thus, he probably has criminal intent required for liability because he had a general knowledge that he committed a crime. He knowingly knew that, and he purposely helped him evade arrest or prosecution. And so, much like everything else, I just want to identify that, this is why it's important to understand the complexities of criminal justice and why you in this class right now is a big deal. So many people only know the basic levels of criminal justice and what the law actually means, but when you start to realize intent and what goes into intent and how people can be liable for intent, even if they're not the one that did the principle, you were just assisting, or you were an accomplice, or an accessory. People don't realize what those are until it happens to them. So I just wanted to take a quick moment to say this is important context that I'm just glad that you're able to learn, even if it's in my class in a college level, but just wanted to put that out there. All right. And of course, like everything else, we have grading. So the type of liability, we have accomplice liability, accessory, and vicarious. And so we grade them at different levels, and we grade them based off of their act and their intent. So again, just to highlight what we've talked about so far, an accomplice, they aid, assist in the commission of a crime, and they have a specific or purposely kind of idea and intent to doing it, and it depends on the jurisdiction. An accessory aids, assists the evasion of prosecution or conviction, high-level misdemeanor or other crimes, and they generally are knowingly plus specific or purposely intended to do that, whereas vicarious is they committed by an individual in a special relationship, and it belongs to an individual in a special relationship with the defendant. And so I really want to just point out this is really good, pretty much overall. I know it's at the end of part 3 chapter, but this is a really good breakdown of everything that we've talked about in this nice little flowchart. So the parties to crime, which is really what we've been talking about this whole time, is the principal, the accomplice, and the accessory, and how they break down, what they require. This is the easy one. The principal commits the crime, but how does an accomplice matter? How does an accessory matter? And what is vicarious liability? They're not directly related because they are passed on due to some kind of connection. And so that takes us to the end. Thank you very much for sticking with it. Like I said, I'm sorry this is going up late. Trying my best. But yeah, once again, I will make this webpage also available if for anyone that's interested to look over some of our crimes and offenses here in the state of Pennsylvania, the Keystone State. But otherwise, thank you very much. Good luck, and I'll see you in the next video. Bye for now.